Legal positivism is a theory about the nature of law. It asserts that law is a system of rules created by humans, not by any higher moral authority. This means that the validity of a law doesn't depend on whether it's morally right or wrong. Instead, it depends on whether it has been created through the proper procedures recognized by a society. Imagine a game of chess. The rules of chess aren't derived from some universal moral principle. They are simply conventions agreed upon by people to play the game. Similarly, legal positivists see law as a set of rules established and enforced by a community. These rules provide a framework for social order and resolve disputes. Legal positivists are not saying that morality is unimportant. They acknowledge that moral beliefs can influence the content of laws. However, they insist that a law's moral merit doesn't determine its legal validity. This distinction between law and morality is central to legal positivism. Klaus Fusser's chapter critiques the traditional separation of law and morality in legal positivism. He argues that law and morality are not entirely distinct concepts. This challenges the idea that something can be legally valid even if it's morally wrong, and vice versa. Consider the example of slavery. In the past, slavery was legal in many parts of the world. This doesn't mean that slavery was morally right. It simply means that it was permitted by the legal system at the time. Fusser's critique allows us to condemn the immorality of slavery while acknowledging its historical legality. The unraveling of the separation thesis has important implications. It calls for a more integrated analysis of legal systems. It also suggests that integrating moral considerations can better protect individual rights. Legal positivists emphasize the role of social facts in determining the existence and content of law. Social facts are practices, beliefs, and institutions that exist within a society. They are observable and verifiable, unlike moral principles, which can be subjective and contested. Laws are created through social processes, such as legislation or judicial decisions. These processes are grounded in social facts, such as the established procedures for lawmaking or the accepted interpretations of legal precedents. The authority of law derives from its recognition and acceptance by the members of a society. Think of a country's constitution. The constitution is a set of fundamental rules that govern the state. Its legal validity doesn't stem from its inherent moral correctness. Instead, it derives from its acceptance by the people and their representatives as the supreme law of the land. Section 4, H. L. A. Hart's Rule of Recognition Identifying Valid Law. H. L. A. Hart, a prominent legal positivist, introduced the concept of the rule of recognition in his book, The Concept of Law. This rule is a fundamental element of any legal system. It provides a standard for identifying which rules are legally valid and which are not. Hart argued that the rule of recognition is not itself a legal rule. Instead, it is a social rule that arises from the convergent behavior of officials within a legal system. These officials, such as judges and lawmakers, accept certain criteria for identifying valid law, such as legislation enacted by the legislature or precedents established by higher courts. Imagine a group of people playing a game with complex rules. To determine what moves are allowed, they might refer to a rule book. The rule book acts as the rule of recognition in this scenario. It provides a shared understanding of the game's rules and ensures consistency in their application. Section 5. Critiques of legal positivism, where morality intersects with law. While legal positivism offers a clear framework for understanding law, it has faced criticism for its perceived neglect of moral considerations. Critics argue that the strict separation of law and morality is unrealistic and undesirable. They point out that moral values often inform the content of laws and influence their interpretation and enforcement. For instance, laws against murder, theft, and assault reflect basic moral principles about the value of human life and property. Critics argue that ignoring the moral dimensions of law can lead to a purely formalistic approach that fails to address substantive injustices. Furthermore, critics contend that legal positivism can be used to justify unjust laws by claiming that their validity is independent of their moral content. They argue that this can create a dangerous separation between law and justice. Section 6. Legal positivism in action, real-world examples. Despite the critiques, legal positivism remains an influential theory in legal philosophy. Its principles can be observed in various aspects of legal systems around the world. For example, the principle of legislative supremacy, which holds that laws enacted by the legislature are the highest form of law, reflects the positivist view that law is a product of human creation. Similarly, the doctrine of stare decisis, which requires courts to follow precedents set by higher courts, highlights the importance of social facts and established legal practices. International law also provides examples of legal positivism in action. Treaties and conventions, which are agreements between states, are considered binding not because of their inherent moral righteousness, but because they have been created through recognized international legal processes. Section 7 conclusion, balancing strengths and weaknesses. Legal positivism offers a valuable framework for understanding the nature of law. Its emphasis on the separation of law and morality, the role of social facts, and the importance of established legal procedures provides clarity and consistency in legal reasoning. However, it's crucial to acknowledge the critiques and recognize the limitations of a purely positivist approach. While the separation thesis allows for a more objective analysis of legal systems, it's essential to remember that law operates within a social context where moral considerations inevitably arise. Balancing the strengths of legal positivism with an awareness of its limitations is crucial for developing a comprehensive understanding of law and its role in society. I'll pause 2S. I bet you didn't know how influential the Autonomy of Law essays on legal positivism by Robert P. George is in the field of legal theory. This significant book is a collection of essays that delve deeply into various aspects of legal positivism. Chapter 1 discusses the theoretical foundations of legal positivism, providing a historical overview and examining its key proponents. Chapter 2 explores the relationship between legal positivism and the rule of law. Chapter 3 addresses the criticism of legal positivism, particularly the argument that it fails to account for the moral dimensions of law. Chapter 4 focuses on the concept of legal validity and the criteria that determine whether a law is valid within a legal system. Chapter 5 delves into the practical implications of legal positivism, discussing how it influences legal interpretation and decision-making. Chapter 6 provides a comparative analysis of legal positivism and other legal theories, such as natural law and legal realism. Chapter 7 concludes the book by reflecting on the future of legal positivism. Each chapter in The Autonomy of Law offers valuable insights into the complexities of legal positivism. Pause 2S. For a deeper understanding of legal positivism, I highly encourage you to read The Autonomy of Law. Thank you for watching, and don't forget to like, comment, and subscribe for more insightful content on law and philosophy.